Right, I think we're going to start. Thank you. There's 130 so people have joined us so far, and more will, I think, will join us. Well, thank you everybody who's taking part in this, and it's a great pleasure and an honour for me to welcome Dame Vera Baird, and I'm not going to give all your initials after your name because it's very impressive. Your career has been incredibly impressive, very varied. You were a barrister. I think that's when we first met, when you were lawyering originally, which was some years ago, I have to say. Of course, you took on some very high-profile cases. You're a QC. You were an MP for Redcar, Spectator, Backbencher of the Year, very impressive. Solicitor General, and a PCC twice in Northumbria, and now for the last couple of years, Victims Commissioner. But throughout that, and I think when you were a PCC as well, a particular interest in victims, and particularly, obviously, women as victims. Which job do you think you enjoyed most, and which job do you think you achieved most in?
Oh, that's really difficult to say.
I didn't tell you I was going to ask that, did I?
What a way to start, Frances. Actually, I've enjoyed them all. The bar was fantastic. I was a jury advocate, always for the defence, and it was marvellous. So you had the intellectual challenge of black letter law with the judge, you had to argue precedent with and so on about points of law, but then you had to write a novel to deliver as your closing speech so that the jury saw things from your client's perspective. So it had an enormous amount of challenge of different kinds in it, and I enjoyed that for many years, and I had a great career there and did some very interesting cases, notably what in those days you wouldn't call it now, were battered women who killed their violent partner, victims of domestic abuse, and ultimately helped to change the law. And then, of course, after that, in a sense, I think I thought that I had been using such skills as I had for other people's interests for quite a long time, and I wanted to drive my own agenda. So I went into politics to try to do things that I really cared very much about. And I did quite enjoy the variety of being a backbencher, and it was great to get backbencher of the year.
Very impressive.
Spectator. Of course, it was the current Prime Minister who was the editor of the Spectator there, and who was there. I think he gave me the award. I can't remember, but how life moves on. I enjoyed that. I was glad when I became a minister, and my greatest pride as Solicitor General was taking the Equality Act 2010 through all its common stages. That was a brilliant piece of legislation. It's never been fully implemented, but even now, it is extraordinarily useful tool. It does need refreshing, and it does need to be fully implemented. Being a PCC was also very different and suited me, I think. And that is when I started to get, as you've worked out, very interested in the position of victims, and that's what led me to become the victims portfolio lead for the Association of Police and Crime Commissioners, and then ultimately to think that is what I'd like to do all the time for a while now. So it's hard for me to pick. I mean, I suppose the bar was very exciting, and I grew up with that, but all of them that I've done since have had their attractions. I've been very lucky.
You have been. It's been a very distinguished career, very impressive. I want to talk about women first, because the Howard League supports an all-party group on women in the penal system, and we've been doing some work. And I know this is very close to your heart as well. We've been doing some work with the police on stemming the flow of women into the justice system, particularly women who don't need to be there. And what we've found with getting information from the police is that a lot of women are arrested by police when in fact they are victims of domestic abuse. And I wonder what you think could be done to ensure that women in abusive relationships are recognised and protected at front line. And this brings in both your PCC role and the Victims Commission in a way, and are not sucked into the criminal justice system and labelled as perpetrators by the police, when first and foremost they are actually victims.
I mean, that's such an important point. The overlap between who's a victim and who is a defendant in the criminal justice system is much, much, much bigger than most people think. And I think the notion that, you know, victims are at war with defendants and that's, you know, that's the fight for victims' rights, defendants' rights, is completely not the case. And it certainly isn't how I do my job now. So, I mean, I do agree with you. I think that your group has found, and some earlier research done by Marianne Hester in Bristol found that often, I mean, I think 3 ways women get arrested who are domestic abuse victims. One, because they're coerced into committing small offences, sometimes delivering drugs, sometimes stealing, or whatever. So they're coerced into that. Let me come back to that. Also, sometimes they react violently back when they've been violently attacked.
That's what police told us, yeah.
Yeah, and of course, a manipulative perpetrator of domestic abuse then gets the police in, so he's got one up on her. Also, I think there's another category Marianne found, which is where the victim has called the police have come, a manipulative perpetrator, you know, makes friends with the police and says she's got mental health problems or something, you know, and the person who's called them is afraid that if they don't do something when they've left, the perpetrator will really take it out of them for complaining, because as you know, I think most people now know, the grip of a coercively controlling perpetrator, when someone tries to escape, has to get tighter and tighter and tighter because that person's afraid of losing them. So the victim's terrified what will happen when the police go, and is also, you know, afraid of not getting some help because they have finally taken the step. So they then sometimes are very difficult with the police, and the police arrest that person. All of those are, you know, result in some women being in custody for tiny offences, nothing like what they've suffered. 2 things here, I think. One is that the police have now started to appreciate this, and I'm a member of a reference group that's run by Louisa Rolfe, who is the National Police Chiefs Council's lead for domestic abuse, and they have started to try and work up a system where when a woman is arrested, an opportunity is taken to ask her about domestic abuse. This obviously needs to go further and to be applied to men and to children too, but let's start where we can start. And of course, there'll be questions about who asks and how you ask and so on, but it is perceived now by the police, just beginning to be, that this is an opportunity when a woman first comes into contact with the criminal justice system to see if there is this driving force. Lots of that clever thinking is good. It's really remarkable insight for the police. A lot of it's driven by HMCPSI, HMICFRS, the Inspectorate of Constabulary. Their leading inspector, Zoe Billingham, on domestic abuse has driven the domestic abuse agenda and has got this up and running as an idea to be developed. That looks to me like a great development. One more thing, I've been working with a team from the Prison Reform Trust and other organisations to try to get an amendment into the domestic abuse bill, which would give a defence for somebody who has committed a relatively minor crime when they are coercively controlled. It's kind of analogous to Section 45 of the Modern Slavery Act, where if you're enslaved, if a reasonable person couldn't do other than the crime, then you've got a defence to raise at court. We've been trying to get something the same for coercively controlled victims of domestic abuse. Now that there's a real understanding that coercive control is a real grip and people's free will is eroded. We haven't succeeded in that, but we are still trying. Helena Kennedy is going to reintroduce it into the laws. So there is stuff happening, and you've put your finger on a very key problem.
There is, and I've known people who've been coerced, women who've been coerced toxic and terrifying it can be, and how difficult it is to spot for family and friends. And
Yeah.
building on that, it's really interesting. Your post at the moment can involve sort of trying to get legislative change and system change, but you can't, I don't think, take up individual cases. Now, sometimes I think it's possible for regulators or inspectors or whoever to get mired in individual cases, but sometimes they can illuminate and be used to push for system change. Is it something you'd like to have the power to do, or actually are you happy with the way that your office is based on system alone?
We would need a whole new team of staff. So there are
Yes.
8 people in my office, all but 2 of whom are part-time. So it's a tiny organization, and we couldn't conceivably do individual complaints at all. So it would be a whole separate dimension with a need for much, much more staff. We do, of course, though we can't take individual complaints, get lots and lots and lots of them. And my approach to them is to look and say, is there something in this that we can derive a policy from, or which challenges a policy that currently is happening? And if so, we will write back to the person who's written to us and say that we can't take their individual case, but we hope it's some satisfaction for them that we are going to raise the matter that caused them the problem as we try and develop policy. That's how we manage it at the moment.
Interesting, yeah, because we too, as loudly, we have a legal team, but we only represent children and young adults, and we get a lot of letters and calls from adult prisoners and do pretty much the same thing. We can't deal with the individual case, but we try to feed that into our campaigning. I want to go on to ask you about, while we're talking about women, and I will move on from women, honestly I will, because recently I was looking at press statements recently, and you made some very strong statements about the failure of the Crown Prosecution Service to protect victims of rape. And I just wonder, and I think there's a judicial review going on at the moment, a court case being challenging the CPS for its failure to prosecute and to support women as victims of rape. What would you like to see changes to the law or practice? How can this be made better?
What's absolutely imperative is, whatever the outcome of the judicial review, and you're right, Francis, it's on literally now, I think its second day was today, is that there is an urgent need to reverse the change of policy that the CPS brought about. So rape is terribly difficult to prosecute, nobody doubts that, but things were getting better, step by step, slowly, with a great deal of input from the previous, from Keir Starmer's legal advisor, who's Alison Levitt QC. She had set up a really excellent course about how to prosecute rape, which countenanced challenging myths and stereotypes, not being afraid of them and saying, well, we won't take that case because they'll say, she was wearing a short skirt, or we won't take that case because she didn't report it for a fortnight and they'll suggest it was consensual and now something's happened to make her change her mind. They were trying to expand what they could do, and if they lost the case because they felt myths and stereotypes, then they learned how to challenge them. That was all going well, and then there was a reversal of that in 2016-17 when they decided that the conviction rate was too poor on contested trials and they could only take more serious cases, which has led to, from 3,500 cases a year for a decade being prosecuted, it dropped by 1,000 in a year after that decision was taken. It dropped by 1,000 the next year, and it's now about 1,800 with a correspondingly very, very few convictions, 1.4%, because of course complaints have rocketed up in the meantime. 1.4% of people who complain get even a prosecution, never mind a conviction. I'm sure the CPS didn't intend. I'm not commenting on whether that was lawful or not, but I don't think they intended the collapse that followed. They urgently need to simply reverse that policy and take rape on as a challenge and take myths and stereotypes on exactly as the CPS were doing and are capable of doing. So they just urgently need to do that and to drive it through their lawyers. And I'm afraid what's happened since 2016-17, because this has been going on a long time, CPS have failed to acknowledge it, is that the police have started to catch this kind of small c conservatism. And so they don't bother now to send cases that they think the CPS won't prosecute. So it's all a very downward spiral. So the link is certainly starts with the CPS, goes through the police. We've got to get it reversed, and a sense of challenge to the difficult job of prosecuting rape in both organisations urgently returned.
Yeah, well, I would, on a personal level, absolutely agree with you. I mean, at the moment, if you're a victim of rape, or if you're a victim of a serious crime, if you're a man or a woman, the chances of that coming to court within the next year or 2 years or even 3 or possibly even 4 years is not great. We know that the whole justice system was a pretty much in a mess for many years, and the court delays were very serious, but the pandemic has made it even worse. And it means that if you're a victim, you will wait a very long time for and of course a witness or a defendant. Our league is we're monitoring the prisons, and people are spending years in prisons on remand now. There's been suggestions from Labour to have smaller juries, and people are looking at different ways of doing it. But from a victim's point of view, I don't know what you're suggesting to government to try and either speed the system up or make it, improve it one way or another.
It is a real a key problem. You're absolutely right. It hasn't just come through COVID. There were absolute failure to properly fund the court system. So there were empty courts. They wouldn't fund recorders to fill the courts. So the backlog was very sizable before COVID ever started. But now it is very sizable indeed. And I'm told I have a phone call with a selection of the PCC funded victims hubs. Victims services are now delivered from the PCC's offices or hubs that are commissioned by them, and I meet with them every fortnight, and they are saying now it's more or less standard to be booking somebody's case in 2022. More or less that is standard. And we have heard it could be an urban myth, cases at the beginning of 2023. This is no good in particular. I mean, it's poor for defendants. It's no good for for victims who have had a serious traumatic experience, such as rape or domestic abuse or serious violence, whose life is put on hold because they can't deal with it whilst the court case hangs over them. You kind of will be having flashbacks, you will be revisiting it, your evidence will get clouded over time because of all of that. So the quality in the end of the product is not going to be so good, but the suffering in the interim is appalling. I don't support Labour's proposals to change jury trial or to allow courts to have a judge and 2 magistrates or whatever the current proposal is for either way offences. I think that the one thing that might be worth looking at of that nature could be temporarily stopping the election for trial and making it only sent by magistrates only. And I say that because the magistrates' courts have come along very, very much faster through the recovery process, and now are, I believe, dealing with more cases than they take on. So there are cases that could be being dealt with of an either way kind in the magistrates' court now, which will take 2 years. Obviously, if you're a cunning defendant and you're worried about the outcome, you will elect trial anyway, won't you, to make sure it doesn't come on. So that's a possibility for me, though it's always been troublesome to take away the right to elect trial. However, that's one thing. So the HMCPS have HMCTS have honestly tried extremely hard. After a bit of a struggle, I'm on the committees that are trying to re-establish the Crown Court, and they have, for the first time just around Christmas, disposed of more cases than have come through nationally. So they are speeding up. They've put all sorts of, plexiglass in jury rooms and in the courts, and devised all sorts of mechanisms. They need a lot more Nightingale courts, which actually can't take custody cases anyway, but to clear lots of stuff out of the Crown Courts that need to have a custodial availability, and more investment to make sure every court is full every day. I am a great supporter of Section 28 of the Youth Justice and Criminal Evidence Act, whereby somebody who is currently, only if they're a vulnerable person, can give their evidence in a video, an ABE, and then have their cross-exam, serve that on the defence, and within a period of a few months, when it's fair and the defence has had enough time to prepare, you do the cross-examination also on video with just two barristers, the judge at court and the complainant across a link. And then the two videos are in a box. The complainant goes about their life. Any question of pre-trial therapy, can probably be taken away, because you can just hopefully hold on that long and have it after the event. So you can move a lot of really vulnerable people out of this queue by using that. We've pressed, HMCTS have now rolled Section 28 out nationwide for vulnerable victims, but it needs to be done for intimidated victims too, the two categories in that 1999 legislation. But I myself don't see that this should be a special measure available only for some people. I think that now we're in this crisis situation with the courts. This is an excellent thing to offer to a far wider range of victims and witnesses, so they can get their evidence over. Those videos can be put in the box and they can be get on with their lives. There's a bit of a move afoot now to try to get the government to consider moving it on to intimidated victims, but also moving it on to a wider range of people, which could, in my view, make a significant difference to the queues. Or even if the queues are to stay, there'd be far fewer people in them who are vulnerable.
I think it's really interesting what you're saying. I mean, the trouble is that quite often reforms like this are piecemeal, and a bit is implemented, a bit isn't. And what you get is politicians stomping around saying how they're putting victims at the centre of the system, and we're going to do this, and actually they don't really mean that, because they're not consulting the properly people, and they're doing a little bit here and a little bit there. Or what they're doing is ramping up punishments for offenders, but claiming that that's supporting victims. And I'm not convinced that that's actually what victims particularly want. Necessarily. And I think we've had a question that was from Crispian Strachan, I think, or Strachan, I'm not sure, I hope I'm pronouncing your name right, about restorative justice. And so I'm sort of rolling two issues in together. One is are restorative solutions better for victims, and do politicians exploit victims partly to punish people more, but also just for their own glorification?
If it's
bigger kinds of politicians here.
If it's Crispian Strachan, he used to be the Chief Constable of Northumbria long before I was the Peace and Crime Commissioner. But it's a very welcome, very familiar name, and a very welcome question. Yeah, I think you're right. Politicians do say we're doing this for victims, but they, victims are not universally baying for blood. I mean, some of them are, but then some of the public are, but a lot are not. They're as varied as you and I. And of course, a lot are traumatized, as I've sought to describe, and living with the consequences. What they want as a group, in a huge generalization from me, is to be treated decently and to be helped to cope and recover by the way they're dealt with by victim services and by the criminal justice system. And that's much more central than, why would somebody whose child has been mown down in a road crash case be bothered what the sentence for rape is? It doesn't make the slightest sense. That's just exploiting, yeah, you know, the good name of victims, as it were, for political benefit. Restorative justice is a different thing. When I was in Northumbria, and if it is Mr. Strachan, he may have noted, we tried our very best to get the numbers of restorative justice cases up. So we, our victims hub, which is called Victims First Northumbria, all of the people who work there were trained in restorative justice. We got somebody from the local yacht to come in and train everybody and be part of that. We moved, with the help of the probation service, 2 probation service people into the Victims Hub. And what we planned was that the Victims Hub would ask the defendants, sorry, or the other way around, obviously, ask the complainants about restorative justice, and the probation staff would ask the people they're used to dealing with, the defendants, about whether they were interested in restorative justice. We got some excellent results, but we got very few. And opening it out to more people seems to be a very, very difficult thing to do. And I'm very positive about it. And I argued that the money that goes to PCCs, specifically earmarked for restorative justice, ought literally to be earmarked, and they ought to have to send it back if they don't spend it on restorative justice, because you can try, as we did, and not have spent it all because you've done so few by the end of the year, and of course you just move it over to other worthy victims' causes. But there would be more of a drive if you were fixed with that money and you either got it spent on restorative justice or it went back. But I think it is quite difficult. What's important to me is that we try to reboot it again now, because the backlog in the courts does mean that at the bottom end of offending in particular, the tendency is to try to take it all out of the criminal justice system and do out of court disposals and so on. I have no objection to that, as long as victims are involved and get a sense of justice about it. But it does seem to me that there is an opportunity there for more attempts to make restorative justice work effectively. It's outside the criminal justice system, isn't it? It kind of almost privatizes justice between the 2 parties involved. So as a sort of bigger concept, it might be quite a difficult one, but I think it can be hugely beneficial to the parties.
I agree. I'm a convert to the whole idea of restorative solutions somehow, and I think, you know, its time has come, but it's not easy. But one thing it does do, I think, some kind of restorative process, it does recognise how complicated things are. I mean, I used to be an elected councillor, and I quite often got neighbour disputes, but where one party would be criminalised, and actually you knew it was a long backstory, it's complicated. And I think so that the separation or the sort of identification sometimes of one lot of people as victims and the other lot of people as criminals is simplistic. And you, I think, did a very interesting report quite recently, particularly on young people, and about how complicated their responses are to domestic violence, and where they may have been victims, where their mum may have been a victim. But you suggested that sometimes they sort of leave. I thought this was really interesting. They leave the young people, perhaps probably young men, leave the domestic birth family or their family and seek an alternative family, which can lead to criminality in itself. So they start off as victims and end up then as criminals. But the criminal justice system doesn't see that. It just sees the end result and an act. It's only an act. It's not a process or a life's experience. Our criminal justice system is very simple in that way and doesn't understand the complexities of what real life is like. I mean, do you want to just say something about the report?
I agree. The report was called Sowing the Seeds, and we just wanted to look and find out about the impact of domestic abuse on children and young people. And I guess we were particularly focused on the advent of the domestic abuse bill, until this bill appeared and has been amended and extended beyond what it first was, there wasn't a recognition that children and young people in the family were victims. They were almost treated as bystanders, and we wanted to look whether that was realistic. So that was our fundamental purpose. But we found out that there are a lot, perhaps that's not so surprising, of different reactions to domestic abuse, and one, particularly boys. And again, I will make it sound like more of a generalization than those who were commenting made it. Boys, don't like what is happening, can't compete with the male who is being the perpetrator. This is the classic case. Can't fight him, would like to stop him, but don't know how to do it. Can't protect their mother, which they would like to do. And so just have no place that's satisfactory in this dysfunctional family. And as you say, as you've put it so well, Francis, they go out and look for another family. And so, it's very easy to see them joining a gang at the end of the street, or being brought into, things like county lines. So sometimes the consequence of that happening is that they become sexually exploited. Sometimes they get exploited and put into criminality, and then end up, though they are truly victims of domestic abuse, perpetrators in the criminal system. There were a lot of other very diverse ways of reacting, but that was a very marked one that I'd never come across before, nor ever thought about. So this, this kind of duality between who is one day a defendant and one day a victim is a very marked change of approach for somebody who's the victims commissioner, I think, and it's a very important understanding for me, which I'm beginning to try to understand more fully and take forward. It's a very good report. It's well worth reading.
I had a look at it, and I would recommend it to people. It's very interesting, and some challenging ideas in there. It's really good. You've talked quite a lot about legislation, and the bill that's going through at the moment that you're working on. What general legislation and policy changes? And this is a really big question, but I think it gives you an opportunity to lay out a whole smorgasbord or a plan or something. What legislative changes would you like if you were the Prime Minister and the Victims Commissioner? What would you like to see most of all?
I mean, well, I suppose what most centrally, there are a lot, as you say, it's a big smorgasbord. And I'm quite a hungry person, but clearly the most direct thing
we all are.
would be the victims' law. We've been promised the victims' law for about 5 years now. And it is high time we got it. And at the moment, it's definitely still on the agenda, but whether it gets into this parliamentary session or it doesn't, I don't know. So, essentially, so the central part of my role is to try to make sure that victims' rights are better dealt with. And we've got a victims code now, a new victims code. We've had one since 2006. In fact, we've had 3 or 4. None of them have been implemented. My predecessor did a survey, for instance, of the victim personal statement for every year for the 5 years of her term as victims commissioner, and it was roughly 14% of people who remembered being offered a victim personal statement. When you get a victim personal statement, which is a right under the Victims Code, it is very satisfying. Indeed, it can be transformative for some people, who have suffered very badly at the death of a child or, their own serious injury. But it's a right, and it's been a right for a very long time, and it doesn't happen as it should. So there absolutely needs to be some mechanism for implementation of all of those rights. We don't have a criminal justice system that deals properly with victims' needs. I understand the adversarial system. Heaven knows I worked in it for long enough, and I have no quibble with it. And I have no interest in undermining defendants' rights. I have said many times, I want to draw a red circle around defendants' rights and keep them safe. But you can do an enormous amount to help victims without coming near the edge of that red circle. So they need quite simple things in many cases, such as being kept informed, being treated with respect. People are demeaned by being a victim of crime. They feel that they've been treated, as a sort of vehicle for somebody else's success or drive or purpose, and they feel undermined. After all, society's let this crime happen to them. Society's got a job to restore their sense of self-esteem, to make them know that they're a valued citizen, to give them the right information, to tell them when someone's arrested, to tell them that there isn't a prospect of finding the person, and so they have to resolve the issue elsewhere, bring them to court in a comfortable way, give them procedural justice, ensure they get the victim personal statement, ensure they are free to say what they want in their own statement. All of those quite straightforward things are in the Victims Code. They're not implemented. It's not that people who work in the criminal justice system are not, are nasty people. They're public servants and they want to do well, but it's not their job. The police are there to investigate, the CPS to prosecute, the judge to see that the trial's fair, and the jury to decide guilt or lack of it. Often there is good treatment because kind individuals will do their best, but systematically there needs to be this kind of parallel system running which recognizes the adversarial role and keeps defendants' rights absolutely secure, but nonetheless helps people to cope and recover by treating them in a decent way. So that would be at the center of a victims law for me, making sure that the Victims Code was implemented and recognizing victims as participants, really, right from the day the offense occurs all the way through the investigation, the court case, and long after. Victims are frequently traumatically affected in some way, and their lives can be changed. It isn't good enough to treat them as a sort of bystander who is not central to the system and so isn't brought into it. So I'm pretty keen on driving that agenda. We are publishing in February a policy paper showing exactly what we'd like to have in a victims law. We've done quite a lot of round tables. We've reached out to all the victims organisations we could find of all kinds to say, what would you like to have in it? People who are victims of mentally disordered offenders don't get the support that even victims of crime get, because then it's not a crime, as it were. They're not a criminal. That's really no good. They can't do a victim personal statement. The criminal injuries compensation scheme.
I'm coming to that.
Okay, well, court let me not give you the full list because they will all come out in February, and that will be our kind of wish list, which I hope has got a bit of coherence around it. But I mean, court-based compensation is very poor. Now, somebody is ordered to pay, £50 at £1 a week. They don't. The court doesn't drive that at all. And you end up with somebody who was their victim kind of in an unhappy relationship over many, many months with somebody who is paying, very difficult probably for them for many, many months. And that's completely undesirable. What has to happen with that, we say, is the court orders it, the court pays it, and the court recovers it from the defendant, as firmly and as less firmly as it chooses. And then that's done. Otherwise it's a kind of insult to injury that you get ordered compensation, get it delivered. So we have a great smorgasbord of things
that sounds
like
great. I should look forward to it. I wanted to talk about the victims' compensation scheme, the criminal case of the compensation scheme, because it was actually something that my organisation championed. Well, my predecessor, Marjorie Fry, nearly 100 years ago, she championed this and helped set it up. But one of the problems that we're concerned with is again this sort of separation of perpetrators or criminals and victims. In that once you've been a criminal, you can't therefore then get compensation if you're a victim. and actually it's a completely different stage in your life. They're not linked, but it's particularly cruel. So I hope that's going to be something that you will seek to change as well.
Yeah, it definitely is. Quite soon after I became Victims Commissioner, I was invited by the judiciary of the Criminal Injuries Compensation Authority to go to their annual conference. And we had an excellent discussion. I was really impressed by their positive approach to their role. And what I think should happen is that the judges should decide whether somebody's convictions ought to have an impact on their compensation or not, because it isn't a clear-cut question that really can be decided on an administrative basis. Sometimes, you know, there may be people who definitely wouldn't want to have compensation. On other occasions, their criminality may have come from the fact that they were a victim in the first place, and it's thrown them into chaos. And rather the process we've been talking about, I think it's a good job for judges to make that decision, set some precedents, drive them down through the compensation authority. Same about, you know, did you contribute to your injury? That's not something that can be tick boxed. You know, they were in the wrong part of the town at the wrong time. You know, what were they doing there on a busy Friday night? If they got punched, it's their fault. They should have been at home or at church. That's completely unrealistic to be brought out. Yeah, forgive my facetiousness, but it's unrealistic.
I know what you mean.
You know,
I know what you mean.
To be dealt with, tick box, wrong place. It's also very offensive to people who've been genuinely hurt. I think these things need discretion. The judges are the people to do it, and if they can set some precedents, it can go down through the administration. I must say I'm really impressed by the Criminal Injuries Compensation Authority's administration at the moment. We said at the beginning, re-traumatizing. I mean, again, my predecessor, Baroness Newlove, did a report about criminal injuries compensation, and she found it was really re-traumatizing. It really made people have to relive it. So we said to the chief executive there, why do people have to write another statement saying what's happened to them? You know, I've been raped and it was like this and like this and like this, or I was beaten up badly like this and like this. It's all in the police documents already. And you rely on the police documents to decide whether the person gets compensation or they don't. Why do you want another statement? So they agreed to pilot not doing so in sex offence cases, and have now concluded that they could do without that quite a lot of kinds of case. And of course, the pressure now is to speed the police up sending the file through so that decisions are not held back. But that's stopping re-traumatization, which was part and parcel of getting compensation until now. Pretty good.
I think that's brilliant. I mean, that's really positive. I'm going to end there because that's a really positive thing. I should look forward to your list and your campaign to get change. Thank you so much. It's been really, really interesting. There's so much that we have, there's confluence of interest there between us. It just shows, I think, very much that defendants and people who commit crimes are often victims, and victims are often, life is complicated. People are complicated. Unlike rocket science, which is mathematics, people are really complicated. I've been sort of following some of the trail of chat, and people are asking for us to send links. We might well do that, but don't forget to look at the Victims Commissioner website, which is really good and easy to follow, and has lots of press stuff, which is easy to follow too, and the Howard League website, which is also very good and very easy to follow. My last plea is to you as an audience is support the Howard League. We're a charity, voluntary organisation, so join and give us all your money. That would be much appreciated. But finally, thank you, Vera. That's been really, really interesting. I'm very grateful to you, and I'm sure that you looking at the number of participants, everybody stayed, which is a good sign. Good audience, and they stayed. So thank you to the people who took part, and thank you to Vera. It's been fascinating. I've really enjoyed it. Thank you.
Thank you. I've really enjoyed it. Thank you.
Good.